22-CR000510E, in which you're charged with one count of simple assault and one count of criminal trespass and damage to property. You've heard me advise you of your rights. Do you object to a video hearing today?
Yes, because
No, ma'am, I don't. I don't.
Okay, who represents Ms. White? Is counsel for Ms. White on the line?
Yes, Your Honor, I do.
Okay.
Maureen
And
McLeod.
thank you. Ms. McLeod is here to represent you, Ms. White, but as you can see, we're both on video. Do you object to her helping you by video?
No, ma'am.
Okay, thank you. Mr. Howard, can I have the history, please?
It's a fifth arrest. Last was 2019. Criminal, hold on. Yeah, possession of drug-related objects, criminal trespass. 2019 misdemeanor possession of marijuana. Before that was an 04 FTA for simple battery. She was recommended.
Okay. Thank you. Whose case is this for the state?
It's mine, Your Honor. Good afternoon.
Good afternoon, Ms. Duncan. What is the state's recommendation?
The state is recommending a $7,000 total surety bond. That's $5,000 on the simple assault and $2,000 on the criminal trespass damage to property. In this case, Your Honor, the victim is Terrence Cleckley. My apologies. That's Terence. Cleckley is Kleeckley. This incident occurred at 5401 Old National Highway in South Fulton. In this incident on December 20th, 2021, the defendant threw household items at the victim in this case during a verbal altercation while the victim was sick, and then retrieved a hammer from inside of the home and went outside and proceeded to strike the victim's Dodge Ram truck, breaking the windows and mirrors. The state is particularly concerned in this case because in case 19-CR007230Y, which is the criminal trespass family violence case, this defendant pled guilty and was sentenced to 12 months probation on January 21st, 2020. And in that sentence, the defendant was directed to have no further violent contact with this exact victim. The state is also concerned about this victim's willingness to return to court because we did find an FTA on the record for 2004. In addition to the bond stated amount, the state is requesting a no further contact with the victim, a stay away from the incident location, no alcohol, drugs, or weapons, and an anger awareness course.
Okay, thank you, Ms. McLeod.
Yes, Your Honor. Your Honor, usually I get an opportunity to speak with my client beforehand. On this occasion, I haven't had a chance to speak with her because the jail did not contact me.
Would you like the opportunity to speak with her now?
I would, Your Honor. Yes.
Okay. Is it possible for you to call the jail, or can the jail put can you put a number in the chat so she could speak with Ms. McLeod so that we could keep going?
yes. Hey, Judge, also Ms. McLeod, is that how you pronounce it?
Yes.
Yes, Ms. McLeod, nobody notified us as far as who was the conflict attorney,
Yes.
so we were not aware of that information.
Come over here.
Okay, there is an email which I received from the court, which was copied to the public defender's
You can okay,
department saying that I was the counsel. So I
Yes.
was waiting for calls and did not receive any calls. Nevertheless, I appeared. Normally the jail calls me, and I think in this instance,
That's fine, Ms. McLeod. Can you speak with everyone now? Is that possible? Is
it
this
is
your only
possible for
client?
me, Your Honor. I am free to speak with everyone.
What is your number,
Okay.
ma'am?
or you can call us at the jail. It's gonna be 404
Just a moment. Let me get my phone and do that now. Yes.
612.
Just a moment. Let me.
Or maybe we could put it in the chat and then go to the next position. So
Yes,
that we
Your
can
Honor. That
keep
would save time for
going.
the court.
And I see Mr. Marcellus on the line, so perhaps we could go to that interpreter position. Is there a position that needs an interpreter today?
Yes, we have an interpreter case. That case will be last.
Oh, okay, there's no way we can take it now?
Hi, good morning. This is afternoon. This is Gerald Combs, the public defender.
Hold on, excuse me,
Is this
Coleman.
Sarah Martinez?
Yeah, that's what I'm trying to explain, Coleman.
Okay, I'm
Okay,
sorry, go ahead.
so there's no way for me to speak to her until we actually get to her case?
That's what I'm trying to explain. We still have to pull her, Ms. Martinez, but she's not here right now. We still gotta pull her.
Okay.
Norris, we can't hear you.
Yeah, there's some terrible feedback happening.
Can we go to position 14?
I believe we're
Norris,
asking
we
to go to
can't hear
position.
you.
Is it position 14 they're asking that we go to? Mr. Marcelo, it seems like it's gonna be quite some time before we can get to you. If you have to drop off and come back, that should be fine.
No problem, Your
Okay.
Honor. I can wait
Position
until
number 14.
you told me.
Okay, yes, we can go to 14, but we're having a lot of problems hearing you. Oh, I think it's gone.
Lord,
Happy Friday, everyone.
I know, right?
Is there, okay, well, position 14 may not be available. Courtroom 2, is there anyone else we could take there temporarily?
Yes, it's gonna be you. Hold on. Hold on. Come on, sir. Mr. Ellison, position 6.
Okay, thank you. And I appreciate you all at the jail. I'm just trying to not have us here until 6 o'clock if possible. All right, good afternoon, Mr. Morris. Are you Morris Ellison?
Go ahead.
Yes.
Your case is 22 CR 00516G. I am Judge Melanie Williams. Your case, in this case, you've been charged with 1 count of battery, substantial physical harm with an offense date of February the 3rd of 2022. You've heard me advise you of your constitutional right to remain silent and your right to counsel. Do you object to a video hearing today?
No.
Who represents Mr. Ellison?
I believe it is also Miss Marine, Your Honor.
Oh, Ms. McLeod, you represent him as well.
I do, Your Honor. I have 4 people on the
Okay.
calendar and I haven't had a chance to speak with any of them.
I understand. Is there anyone at courtroom 2 that Ms. McLeod does not represent, that does not need the interpreter that we could go to?
Yes.
Okay.
Come on. Greenish? You already spoke. Everybody else? Okay, I'm gonna grab the people who spoke to somebody. Come on. Yeah, just y'all two, that's it. You sit right here. Yeah. This is position 8, Mr. Grealish.
Okay, before we start, who represents Mr. Grealish?
Good afternoon, Your Honor. That would be me, Daryl Coleman, the public defender.
Okay, I just wanted to make sure it wasn't Ms. McLeod as well. Just, okay, thank you, Mr. Coleman. Please hold 1 second. Are you Jonah Grealish?
Yes, ma'am.
Okay, Mr. Grealish, your case is 22 CR 0000517H, in which you're charged with 1 count of driving under the influence of alcohol under the age of 21, 1 count of possession of an open alcohol container, and 1 count of failure to obey traffic signs, each with offense dates of February the 3rd of 2021. You heard me advise you of your right to remain silent and your right to counsel. Do you object to a video hearing or to Mr. Coleman assisting you from a remote location today?
No, ma'am.
Thank you. I appreciate that. Mr. Howard, can I have his history, please?
First arrest.
Okay. Thank you. Whose case is this? Your case as well, Ms. Duncan?
Yes, Your Honor.
And the state's recommendation?
The state is requesting the bond remain as set. It is currently set at $1,000 for the DUI, well, surety, $1,000 for the DUI under 21, $1,000 for the possession of an open container, and $500 for the failure to obey the control device. In this case, Your Honor, the defendant was noticed by a police officer failing to stop at a red light prior to turning right and almost ran into the police officer's vehicle. The officer had to slam on brakes to avoid the accident. The report indicates that this incident was captured on the dash camera. Once the police made contact with the defendant in this case, the officer noticed alcohol on the defendant's breath and also observed an open can of Fort Loco in the car. The defendant admitted to having drank that night because this happened around 11 p.m. and within the last 2 hours. And once identified, the officers realized that the defendant in this case was under 21, and that is it, Your Honor, for this case. Due to that, we're requesting the bond remain as set, no driving and no alcohol, drugs, or weapons. And this defendant, my apologies, this defendant did not do well on the field sobriety test and blew a 0.03, and the legal limit for a person under 21 is 0.02.
Okay, thank you. Mr. Coleman?
Your Honor, I would be requesting a signature bond from Mr. Grealish as this is his first arrest. He went as far as the 10th grade. He is 18 years of age, currently works for DoorDash, residing with his mother, lifelong resident of Atlanta, Fulton County. Again, I'd be requesting a signature bond if this is his first arrest.
All right, thank you, Mr. Coleman. I appreciate it. At this time, Mr. Grealish's bond is going to remain as set, $1,000 for count 1, $1,000 for count 2, and $500 for count 3. He is to have no driving as a condition of this bond and no alcohol, drugs, or weapons.
Thank you, Your Honor.
He will be reset to that SAP calendar on the 17th where this can be revisited. All right, best of luck to you, Mr. Grealish. Can we move to another position? Is there another?
Yes, we can move on to the next case, Judge. We can go to position 1, Mr. Bernard.
Okay.
Judge, what was
And
that?
who, 2,500. Who represents Mr. Bernard before we begin? Is it you, Mr.
That
Coleman?
would be me, Your Honor.
Okay, just making sure. Thank you. Are you Devontae Bernard?
Go ahead.
Mr. Bernard, I am Judge Melanie Williams. Your case is 22 CR 0000513F, in which you're charged with 1 count.
Goodbye.
Is there something else being said? Okay, you're being charged with 1 count of battery family violence, 1 count of cruelty to children in the 3rd, and 1 count of hindering a person making a telephone call, emergency telephone call, each with offense date of January the 30th of 2022. I've advised you of your constitutional right to remain silent and your right to counsel. Do you object to a video hearing today or to your attorney, Mr. Coleman, assisting you by video? Do you object?
Might mute it.
He's muted. Oh, he's muted. Do you object? Just shake your head. Yes. Okay, you object? Can you unmute him in courtroom 2 just long enough for him to tell me if he objects?
Go ahead.
No. No.
Okay, thank you, Mr. Howard.
I got first arrest.
All right, Ms. Who represents, whose case is this for the state?
Ms. Gidry, Your Honor.
Okay, Ms. Guidry, I see you on the screen now. What is the state's recommendation?
Your Honor, the state's recommending a $6,000 surety, $4,000 for count 1, $1,000 for count 2 and count 3, a stay away from 201 Marsh Trail Circle, Sandy Springs, no further contact with Talisha, that's TALISHA, Parks, common spelling, 1 day anger awareness, and no alcohol, drugs, or weapons. This is largely due to the facts of this case. Your Honor, he got upset because the victim wanted more time with her daughter as she was playing with her daughter in the room. He got upset. He drug her out of the room. She sustained a rug around her knee. She then struck the defendant multiple times to let her go. He then slammed her against the wall and picked her up and threw her against the couch. As she screamed for help for neighbors to help her, he put a pillow over her face. At this time, her daughter was standing in the living room and watched the entire incident. When Ms. Parks was able to get free from the pillow, she asked her daughter to call the police. She attempted to call 911, but the defendant took her phone and would not let her call. She then ran to the door to attempt to get help, but the defendant blocked the door and pushed her back. She was finally able to grab her daughter and go into her daughter's room. And when she awoke, the defendant was gone. Your Honor, we do understand that this is defendant's first arrest. However, given the nature of the crime and that this did occur on the 31st of January, we are concerned for the victim's safety. So that's why we're asking for the stated bond.
All right, thank you.
You're welcome.
I'm gonna sound for the victim at this time. Is the victim last name Parks present on the screen? Hearing none, Mr. Coleman.
Your Honor, I would be requesting a signature bond from Mr. Bernard as this is his first arrest. He is a high school graduate, currently works as a fitness trainer. He is the father of one child, age 11, resident of Atlanta, Fulton County. I will remind the court at this time that these are just allegations against my client. Again, based on his lack of criminal history, I will be requesting a signature bond.
All right, thank you, Mr. Coleman. At this time, I'm gonna do a split bond. On count one, he's gonna receive a $2,500 surety bond. He is to stay away from the incident location and have no further contact with the victim. Last name Parks, no weapons, drugs, or alcohol. As to count 2 and 3, he'll receive a $1,000 signature bond through the jail.
Thank you, Your Honor.
All right, is there anything further from either party?
Nothing further.
I just wanted to clarify what the bonds were. It's $2,500 total on the battery and cruelty.
2,500 for count 1, 1,000 signature count 2, 1,000 signature count 3.
Brown,
Okay, so 2,000 SOB
Yeah,
total.
through
Okay,
the
thank
jail.
you.
And he's, because of the surety on count 1, he will also be reset to SAP on the 17th.
Thank you, Your Honor.
All right, anything further? If nothing further, we can move to the next position.
next, we got position 3, Mr. Brown.
Okay. And Mr. Coleman confirming this is your case as well?
It is, Your Honor.
Thank you. Are you Deontay Brown or Deontay Brown?
Yes, ma'am.
Okay, Mr. Brown, your case is 22 CR 0000514C, in which you're charged with 1 count of simple battery and family violence with an offense date of April the 3rd of 2020. You've heard me advise you of your constitutional right to remain silent and to counsel. Do you object to a video hearing today, or do your attorney assisting you by video? I'm sorry.
We cannot hear you,
We
Norris.
can't hear you at all, and do you object, Mr. Brown?
No, ma'am.
Okay, thank you. We can't hear you. Jail court, is this jail court's iPhone? Is really a lot of
Yeah,
feedback. We can't hear you at all. Okay, Mr. Howard, can you give me Mr. Brown's history?
This is Deontay Brown, correct?
Correct,
Yes.
position 3.
This is his first adult arrest.
Okay,
You don't want juvenile history, do you?
no, thank you. All right, Ms. Guidry, this is your case as well?
Yes, Your Honor.
Okay, what is the state's recommendation?
We're recommending a $4,000 surety bond, a stay away from 285 Howell Terrace, Atlanta, no further contact with Tamia Williams, 1-day anger awareness, and no alcohol, drugs, or weapons. This is due to the nature of the crime. The defendant and the victim got into a verbal argument over money. As she was trying to leave, the defendant pulled her out of the car and then began punching her. And then he slammed her on the ground, pulling out one of her braids. The parties do have 2 children together. We do understand that this is his first adult arrest, but because this is a bond hearing, we are able to speak about juvenile records. We would like to note that he has 7 thefts and 2 burglaries. We do not know the dispositions of those juvenile charges. So given the nature of the crime and his juvenile history, that's why we're asking for the recommended bond.
All right, thank you. Mr. Coleman?
Yeah,
Mr.
Your
Coleman?
Honor, this being his first adult arrest, I will be requesting a signature bond, even if you take into consideration his juvenile history, and I'm not exactly sure if that should be considered at that time. I did not hear that he had any violence in that history either. He is a high school graduate. He is not working, therefore he has no money to post for bond. His father of 1 child, age 4, lifelong resident of Atlanta, Fulton County. Again, based on his lack of history, I will be requesting a signature bond.
All right, thank you. At this time, I want to confirm that offense date is correct in April the 3rd of 2020.
That's
Is that
what
That's what the date is indicated on the warrant.
Okay.
So almost a year ago.
Okay, just wanted to confirm. At this time, Mr. Brown is gonna receive a $2,500 signature bond through pretrial services. He is to have no further contact with the victim, last name Williams. He must stay away from that address on Howell, I believe it was Drive or Circle. He is to have no weapons, drugs, or alcohol as a condition of his bond, and he must take a one-day anger awareness course.
I'm sorry, was that 1 day anger awareness?
Yes.
Thank you.
Thank you,
All
Your
right.
Honor.
Is anything further from either party at this time?
No,
Nothing
Your Honor,
further.
thank you.
If not, best of luck to you, Mr. Brown. Who do we have next?
I'm sorry, can you please repeat the bond, Judge?
$2,500 signature
Is it through the jail or
through
pretrial?
pretrial services.
Thank you. Next, we have position 5, Mr. Denard.
Okay.
What's the date? What's the date? They're paying.
All right, Mr. Denard, your case is 22 CR 0005158, in which you're charged with possession of marijuana less than an ounce and possession and use of drug-related objects. You have an absolute right to remain silent, and you have a right to an attorney at this hearing. Do you object to a video hearing at this time, or to your attorney assisting you remotely?
Say one more time?
Do you object to a video?
No, ma'am.
And do you object to your attorney assisting you by video?
No, ma'am.
Thank you. Mr. Howard?
This is third adult arrest. 2018 fleeing or attempt to elude police. You got pretrial diversion for that, 6 months probation. 2019 possession of a Schedule 1 or 2 controlled substance. Misdemeanor possession of marijuana. He's on probation for that now in Fayette County. They gave him 3 years probation back in November.
Okay, thank you. Ms. Guidry?
Yes, Your Honor. He currently has a $2,000 surety bond that was set only on the possession of marijuana. We're recommending $1,000 surety, $500 for each count, and no alcohol, drugs, or weapons. This is due to the defendant now being on pretrial diversion, and it's still pending, and he knows that he's not supposed to get in trouble as a result of that. And just a little background on the case, officers were attempting to pull over a vehicle. The vehicle continued. It ended up crashing into the trees. The driver and 2 other occupants got out of the vehicle and ran. The defendant stayed at the scene. The officers searched the vehicle due to them smelling an odor of marijuana. They found a small blunt located on the dash and a scale located inside of a bag. The defendant was the owner of the vehicle, so they gave him those charges.
All right, thank you, Ms. Guidry.
Yeah.
Mr. Coleman?
Your Honor, I would be requesting a signature bond from Mr. Denard. Referring to the warrant, Mr. Denard was not the driver of this car. He is went as far as the 10th grade. He is not working, therefore he has no money to post for bond. He is the father of a 2-year-old child. It's been a while since I've seen this charge of possession of a drug-related object. Typically, the state would dismiss their charge. It's also been quite a while since I've seen anyone in court charged with possession of marijuana either. Again, I'd be requesting a signature bond.
All right, thank you. At this time, Mr. Denard is going to receive a $2,000 signature bond through the jail, $1,000 for count 1 and $1,000 for count 2. He is to have no weapons, drugs, or alcohol as a condition of his bond.
Thank you, Your Honor.
Thank you.
All right. Anything further?
Nothing further.
All right, we can go to the next position.
Next, we got position 7, Mr. Garrett.
All right, good afternoon, Mr. Garrett. I'm Judge Melanie Williams. Your case is 22 CR 0000511B, and what you're charged with 1 count of battery and 1 count of simple battery family violence, each with offense dates of February the 3rd of 2022. You've heard me advise you of your right to remain silent and your right to counsel. Do you object to a hearing, or to your attorney assisting you by video?
No, ma'am.
Thank you.
Yes.
Mr. Howard?
7 total. 2015 ag assault arrest. 2017 battery, non-pros, 2 counts. 2019 battery arrest. 2019 misdemeanor possession of marijuana, felony theft by receiving, possession of a knife or a firearm during the commission. That's open 19 SC 170913. He has an open marijuana with intent and loitering 20 SC 174503. He had
That's
one,
good.
he got out of state history from Ohio, 2021, disorderly conduct.
They do that to me all the time too.
Who's talking?
Yeah, she's like a supervisor.
Daryl, mute your mic, please.
Our supervisors can't even look up who's in what court.
Mr. Coleman, yeah, please mute. We can hear whatever's happening in the background.
Yeah.
But I think that's good, Mr. Howard. I have a good picture.
I
Thank you.
apologize, Your Honor.
Ms. Guidry, please, your recommendation?
Yes, Your Honor, we're recommending a $6,000 total surety bond, $3,000 for each count. No further contact with Destiny, DESTINEE, Stewart, common spelling, and Jade Quick. A stay away from 2144 Old Madison View, Atlanta. 1-day anger awareness and no alcohol, drugs, or weapons. Your Honor, in this case, it was learned that the defendant struck Destiny Stewart several times with an open and closed hand. And as Jade Quick tried to separate the two, the defendant struck Ms. Quick, causing her nail to break, pain and bruising to several fingers. Ms. Stewart and the defendant at the time did live together, and this event did occur on the 3rd, yesterday. We're particularly concerned that the defendant is a flight risk given that he has criminal history out of Ohio. He has an open case right now in Ohio for disorderly conduct, misconduct at emergency, and resisting an arrest. And we're particularly concerned with the victim's safety. So that's why we're asking for that recommendation.
All right, thank you. Mr. Coleman?
Your Honor, I will be requesting a signature bond from Mr. Garrett. He is 28 years of age. He's currently a student at University of Phoenix. He is employed by AG Entertainment. Has very little income, money to post for bond. I will remind the court at this time, these are just allegations against Mr. Garrett. Again, I'd be requesting a signature bond or in lieu of that, a low bond.
Thank you.
I believe the simple assault charge was that dismissed by the state?
Yes, the simple assault was dismissed. He only has a battery and simple battery family violence.
All right. At this time, Mr. Garrett is going to receive a $2,500 surety bond on count 1 and a $2,500 surety bond on count 2 for a total of a $5,000 surety bond. He is to have no further contact with the victim, last name Stewart, and he is to stay away from the incident location, have no weapons, drugs, or alcohol. Should he have any items at that stay away location, he can return one time with a member of law enforcement to get his items. Is there anything further from either party?
No,
Nothing further.
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Mr. Garrett. We can move to the next position. Is
Next.
there another position we can go to?
Position 16, Mr. Taylor.
Okay. Mr. Taylor, good afternoon. Your case is 22 CR 000-509F, in which you're charged with 1 count of battery of family violence with an offense date of April the 6th of 2021. You've heard me advise you of your constitutional right to remain silent and your right to counsel today. Do you object to a video hearing or to your attorney assisting you remotely?
No.
You said you do or do not?
I do not.
Thank you. I appreciate that. Mr. Howard, can I have the history, please?
Can hang it up.
Mr. Howard, you with us?
Oh, I was just talking, my bad.
I
25
didn't
total.
hear a thing you said. Okay.
I know, I'm starting over. 25 total. Last arrest was in March 2021. Theft by taking, possession of amphetamine in Cobb County. Appears to be on probation in Fulton for 5 counts, participation in criminal street gang activity, 3 counts smash and grab robbery, burglary first degree, false statements. 2017 failure to appear. Got a probation violation from 2015. Underlying charge was theft by receiving. 2015 theft by receiving conviction. Abandonment of dependent child conviction, 2014, 2012 robbery by sudden snatch arrest, 2012 probation violation, 2011 burglary conviction, and the '08 felony theft by receiving conviction. That's enough.
That's a clear picture. Thank you.
Somebody
Ms.
knocking.
Ms. Duncan, is this your case?
Yes, Your Honor, this is my case. This incident took place on April 5th, 2021 at 1381 Kimberly Way Southwest in Atlanta, Georgia. The victim in this case is Jerica Johnson. We have that spelled as Jereca Johnson, common spelling. At the time of the incident, Ms. Johnson was the other person living in the same household. In this case, the state is going to be requesting a $5,000 surety bond. Given the defendant's history of 25 cycles, I counted at least 27 count convictions since 2013 and the failure to appear. In this incident itself, it stemmed from an argument that was going on the night before, where the victim in this case asked the defendant where her Apple Watch was after she got out of the shower. He said he didn't know, but she knew that he had it, but she just let it go. She stated that she further went to work the next day, and while at work, the defendant in this case began calling and texting her, saying that he knew that she had been texting other people, another guy, on her phone. The dispute continued, and when she walked in the door from work, the defendant in this case punched her in the mouth with a closed fist, causing her lip to bust and swell. The victim in this case stated that the defendant wanted to keep arguing, but she told him that she was not going to continue fighting because her kids were present. In this case, Ms. Johnson did advise the defendant that she was going to call the police, and he stated to her that he was going to sit there until the police arrived, but eventually, before they arrived, he left the location. They were dating and they were living together at that time, but they don't have any children together as of the date of this incident. Our victim advocate did attempt to make contact with this victim. However, the number was not able to accept calls due to the violent nature of this offense. And the history as stated, the state is requesting a $5,000 surety bond for the safety of this victim, no further contact with this victim, a stay away from the incident location, 1 day anger awareness.
All right, thank you. Ms. Kim, do you represent Mr. Taylor?
Yes, Your Honor. Mr. Taylor he has been living here his all life, so he does not have any flight risk because he also has 3 children here in Georgia with Miss Jerica Johnson. They are actually still living together. This incident happened on April 2021, about a year ago, maybe 10 months ago, and they have a good relationship now. And Miss Johnson want her to come back, and they want to have a relationship continuously. And right now, he has been working ever since he got out of the jail 2020. Last 14 months, he has been working 2 jobs diligently to provide bread for his children. He works as a machine operator from 7 a.m. to 3 p.m. and then another job at CKS Packaging Company from 3 p.m. to 11 p.m. And he has a GED, and he would like to get requests for signature bonds first. If not acceptable, we would like to request for $300 surety bond, Your Honor. Thank you.
Okay. I'm sorry, was someone speaking? Ms. Kim, now you said that they've been living together, and you personally have spoken with the victim in this
No, I
case?
tried to, no, Your Honor. I called, but nobody was answering the phone, Your Honor.
Okay. Because we have not had direct contact from either party with this victim at this time, I'm gonna give Mr. Taylor a $3,000 surety bond. He is to have no further contact with the victim because no party has spoken with her. If the case can be revisited at the SAP calendar, she can make a statement at that time if she wishes to have contact with Mr. Taylor. He is to stay away from that address. He can return one time with a member of law enforcement to get whatever items he may have there just while he's on bond. And again, this can be revisited at the SAP calendar on the 17th.
Thank you, Your Honor.
Thank you,
All
Your
right,
Honor.
anything for, oh, and he is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you.
All right, best of luck to you, Mr. Taylor. Can we move to the next position?
Yes, Judge, the jail court's
Can
iPhone.
anyone hear me? You guys can hear me?
Yes, it is not that clear, but we can hear you. Is that position 14 on the jail court iPhone? No, we
Can you
can't
hear
hear you. We cannot hear you, no.
I can hear you.
It's cutting out every couple words.
I'm only saying a couple of words. Can you hear me? Number 14,
can-
Mr. Schoenhofer.
Okay, we can hear you, but it kind of cuts out a little bit. We'll go to position 14. We can't see you either.
Mr. Schoenhofer.
It's cutting out really badly. Are we still attempting to go to position 14? Oh, I see jail court iPhone is back.
Right here. Yeah,
Am I the only person having
right
problems
here, Your
hearing?
Honor.
Am I the only person having problems hearing on that jail?
No, Your Honor.
Okay, we're really struggling to hear jail court iPhone.
And I wanted to let you know, Your Honor, that I've spoken to all my clients. So whenever the court wants to bring
Okay.
them back up, I'm good.
Thank you, Ms. McLeod. I'm gonna try to go to position 14, since we've been trying that sometime. Can we try to hear from you again, Deputy? Okay, I'm not sure that's gonna work. Can we go to a position at courtroom 2 in the meantime?
Yes, that's fine. We can go to position, Ms. White. Please, position 17.
Okay, I believe we started that and I heard the state's recommendation. I believe the state recommended 5,000 for count 1 and 2,000 for count 2. Is that correct, Ms. Duncan?
Yes, Your Honor, given the fact that the defendant is currently sentenced to probation, and as a part of that probation, the defendant was supposed to have no further violent contact with this exact victim.
Okay, I see the victim is present on the screen. Mr. Cleckley, do you wish to make a statement at this time? Mr. Cleckley, if you're present, this is your opportunity to speak to the court. I need you to turn on your video if you'd like to make a statement.
Who are we on?
Position
ma'am.
17.
And
She's on- He's on probation?
My apologies, Your Honor. The state is requesting 7,000 surety, 5,000 for the simple assault, and 2,000 for the criminal trespass damage to property.
Okay, and there was a question about whether or not she was actually on probation.
Sentenced to 12 months on January 21st, 2020 by Judge Edie in case 19 CR 0072330Y, which was criminal trespass, family violence, where she pled guilty. And a part of that condition was no further violent contact with this victim.
Okay, thank you. Mr. Cleckley, do you wish to make a statement to the court at this time?
Yes, ma'am.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth under the penalty of perjury?
Yes.
All right, what would you like to tell the court today?
Well, on the day of the incident, I called the police because we had an altercation. No physical altercation. She went outside. She was actually was finna bust my window, and I had already called the police and everything. She didn't bust my window. She just walked off. She hit the window a couple of times. It didn't bust. She walked off, and I was trying to have the officer understand that I don't know how a warrant got taken out on her or anything because we still live together and everything. And ever since that incident, everything been fine.
All right, so do you live in fear of the victim, of the defendant at this time?
No,
Mr.
ma'am,
Tucker?
and this gonna cause her to lose her job and everything. And I wasn't trying to make this kind of problem.
Okay, thank you, Mr. Cleckley. I appreciate that. Ms. McLeod?
Yes, Your Honor. My client has lived in Atlanta all her life. She is a mother of 3 children. They live in the incident location. She lives in an apartment at that location. She and Mr. Cleckley had been in a relationship for over 11 years. It was a long-standing relationship, and they have had arguments before, but like he said, that she tells me there was no physical violence with him this last time. They did have an argument, and she has told me that she went to work, and she works at the airport. She went and her badge would not work because apparently this popped up, and she can't work. So it's going to be an issue with her because she doesn't really have any help, and she does have 3 children, Your Honor. She's not able to post bond. So I am requesting that the court consider giving her a signature bond, Your Honor. I don't think that she is a risk to Mr. Cleckley, and she does have the children, and she has no other resources.
All right, thank you. Anything further, Ms. Duncan, at this time?
Just given the current facts as stated in the sentence imposed currently, the state requests a bond and conditions as stated.
Thank you. Any response, Ms. McLeod? Since I let Ms. Duncan make a brief statement.
Your Honor, I think the no violent contact is good. And the alleged victim has stated that he's not at all afraid of my client, Your Honor, and I think that is significant. I don't think she's a risk, and she is essentially indigent because she's unemployed right now. Therefore, I think she is a good candidate for signature bond, Your Honor.
All right, thank you. At this time, Ms. White is going to receive a split bond. On count 1, simple assault, is going to be a $1,500 surety bond. On count 2, it's going to be a $1,500 signature bond through the jail. She is to have no further violent contact with Mr. Terrence Cleckley. She is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you, Your
Anything
Honor.
further from either party at this time?
Thank you, Your Honor.
All right, best of luck to you, Ms. White. We can move to the next position.
Next is position 2, Mr. Boozer.
All right. All right, Mr. Boozer, your case is 22 CR 00512Y, in which you're charged with 1 count of simple battery against a person either 65 years or older or who was pregnant at the time, with an offense date of December the 12th of 2021. I've advised you of your constitutional right to remain silent and to counsel. Do you have any objection to a video hearing or to your attorney assisting you by video today?
No.
Okay, Mr. Howard?
23 total. Last arrest was January 31st, 2022. Simple assault in the cab, that's open.
Okay.
Got an open burglary, 2nd degree in Fulton. Theft by receiving, felony, and suspended license. Hold on, Judge. I got 2012 ag assault conviction, criminal damage to property, 2nd degree conviction, probation violations, underlying charges, battery and robbery by force. 2011 obstruction conviction, got another probation violation, got battery convictions. You need more, or that's enough?
That's good, thank you. Oh, one, did you see any FTAs? That's the only other question I have.
What I said, probation violation.
Yeah, you said probation violation. I was wondering.
Yeah.
That's good. That's fine. All right, Ms. Guidry.
Yes, Your Honor, we're recommending a $5,000 surety bond, a stay away from 2500 Center Street Northwest, Atlanta. No further violent contact with Shirley Simon, 1-day anger awareness, no alcohol, drugs, or weapons. Your Honor, in this case, they spoke with Shirley Simon, who is the defendant's mother. She was 76 at the time of this incident, who stated that the defendant attacked her for no reason after she finished showering. She stated that he began to hit her and picked up a chair and threw it at her, striking her in her right shoulder. She had no visitors but complained of back and shoulder. We're particularly concerned with the victim's safety in this case, given her age. Your Honor, she's 76, as we stated. However, we are asking for no further violent contact because we did talk to the victim. She did say that she didn't want to press any charges. However, we do understand that, but given what the defendant did, we're concerned. So we're asking for that stay away. We did see some fade to appears, the last being in 2011, and he had 2 counts in 2003. And given those probation violations, he may be a flight risk. And as pretrial stated, he does have 2 open cases, 1 out of DeKalb and 1 out of Fulton County. And that's why we're asking for the recommendations.
So you're asking for no further violent contact, but you still want him to stay away from the incident location?
Yes.
Okay. All right, Ms. McLeod.
Yes, Your Honor. As the prosecutor mentioned, this is my client's mother, who is the alleged victim. My client informs, Your Honor, that his mother is a chronic alcoholic. He does visit her from time to time and he tries to help her out. But sometimes when he goes there and he doesn't have any money to give her, she gets upset with him and sometimes she gets violent. He said he would never touch his mother, he never has, and that it is absolutely untrue that he physically assaulted her, because he would not do that to his own mother. He said he did go to the house and he wasn't able to give her any money and she got upset and she called the police. My client doesn't have to go back to the location, Your Honor, and he certainly would not have any kind of violent contact with his mother. He does tell me that he currently lives in DeKalb County with his fiancée, and that is where he would go when he gets out of court. He was working, Your Honor, but believes that he has now lost his job because of his incarceration. So he is essentially indigent right now, Your Honor. So I would ask the court to consider giving him a signature bond, or if the court is not inclined to give him a signature bond, to give him as low a bond as possible. His mother has indicated, as the prosecutor said, that she has no wish to press charges against him. I think part of that is because she knows that he's not any kind of threat to her, and she knows what the nature of their interaction usually is, that, you know, if she gets upset when he doesn't give her money. So I'm asking the court to consider all of that. And he's had probation violations, but there was no failure to appear on his record based on what I heard, Your Honor. So I believe that he would show up for court if allowed to go to get out on a signature bond and get back to the possibility that he may still have a job.
Thank you, Ms. McLeod. At this time, Mr. Boozer is going to receive a $3,000 surety bond. He is to have no further violent contact with the victim, and he is to stay away from the incident location. He is to have no weapons, drugs, or alcohol as a condition of his bond.
Thank you, Anna.
Thank you.
Thank you. Is anything further from either party?
Nothing
If
further.
not, best of luck to you, sir. And can we move to the next position?
Your Honor, can you hear me?
Yes, we can.
Okay, but this
Yeah.
is the only thing, this is not position 14.
Okay, let's go to that position.
This is the breakout that I need with Mr. Coleman and the Spanish interpreter for Mrs. Martinez.
Oh, okay. Mr. Marcelo, are you still here? And Mr. Coleman, are you present? They'd like, Mr. Jordan, can you put them into a breakout room? And who needs to be in there again? It's Mr. Coleman, Mr. Marcelo, and jail court iPhone, correct?
That is correct.
Okay. Mr. Jordan, if you could do that breakout, that would be great. And then can we go to another position in courtroom 2 while that's happening?
I'm sorry, repeat that again, Judge?
I was asking if we could go to another position at courtroom 2 while that breakout was happening, if possible.
Yes, position 6, Mr. Ellison.
Okay. Mr. Ellison, I think we brought you forth before. I gave you your explanation of rights and asked if you objected to the video. So I'm gonna go straight to Mr. Howard. Mr. Howard, can I have Mr. Ellison's history, please?
This is 8th arrest. Last arrest was 2010 for DUI.
Okay.
And suspended license. Those were convictions. The other 2 charges were dismissed. Before that was 04 probation violation for eluding police, suspended license, not prosecuted. 04 sexual battery dismissed. He's recommended.
Okay. Thank you. Ms. Guidry?
Yes, we're recommending a $2,000 surety, a stay away from 234 Memorial Drive Southwest, Atlanta. No further contact with John Tyndall. 1-day anger awareness and no alcohol, drugs, or weapons. Your Honor, here, John Tyndall told the officers that he and the defendant got into a verbal argument because they found out that they were involved in a relationship with the same woman. The defendant pulled out a can of pepper spray and sprayed him in the face, causing severe red eyes and itchiness in his facial area. At the time, the defendant did exhibit signs that he was under the influence of alcohol due to him having slurred speech and not being able to describe what happened. Your Honor, we're particularly concerned that the defendant may commit this crime again, given that he found out the nature of what was going on with his relationship. So we're concerned for the victim's safety, and he may be at risk of reoffending. That's why we're asking for this stated recommendation.
What was the stay away address again, Ms. Guidry?
234 Memorial Drive Southwest. It's in Atlanta.
Okay, thank you.
You're welcome.
Ms. McLeod?
Yes, Your Honor. The address which the prosecutor has stated it's an apartment complex, Your Honor. My client lives in an apartment complex. Okay. And apparently this gentleman does not live there. So they do not live together. That's one thing. It's not someone that he knows. He tells me that what happened was that he saw this person running towards him and he thought he was going to be attacked. So he was defending himself when he used the mace to mace this person. My client is disabled, Your Honor. He's not employed because of his disability. This is his home where he lives. He doesn't have any other place to go. And as I stated before, the alleged victim is not any kind of close relationship to him or anyone and does not live at the same place. So therefore, there's no need for him to stay away from his home since they don't occupy the same space. My client has no significant criminal history, as the court can see, and the last thing that is alleged to have happened was in 2010, which is a long time ago. So I would request a signature bond for my client, Your Honor.
Before I go, I want to go back to the stay away address. You said it's an apartment complex, and there's Miss Guidry. Did you have any information that the victim lived in that same complex and just had a different unit number, or does he completely not live at that location according to your information? I understand Ms. McLeod's presentation regarding it. What is the state's information regarding that address?
Give me 1 second. Okay, so I have that our client lives at 371 at that apartment complex, and Ms. McLeod's client lives at 112. So
okay, so the 234 is just where he happened to be standing.
Yes, they both live at that address, but my client lives at, the victim lives at apartment 371.
Okay. All right, I understand now. All right, at this time, Mr. Ellison, is gonna receive a $4,000 signature bond through pretrial services. He is to have no weapons, drugs, or alcohol as a condition of his bond. He is to have no further contact with the victim, last name Tyndall. He must stay 1,000 yards away from that victim. He must also stay 1,000 yards away from Mr. Tyndall's unit, which I believe is 371.
Yes.
Is that correct? So he must stay 1,000 yards away from 371, as is best applicable. It sounds like his unit is further away, so he can go directly to his own unit, but he needs to stay away from that other part and not linger about at the apartment complex. All right, is there anything further from either party?
Are you ordering a one-day anger awareness?
I am not at this time.
Okay.
Thank you, Your Honor.
Nothing further.
All right, thank you. Best of luck to you, Mr. Ellison. We can move to the next position.
Position 4, Mr. Coulson.
Okay. Good afternoon, Mr. Coulson. I'm Judge Melanie Williams. Your case is 22 CR 000518D, in which you're charged with 1 count of simple battery family violence with an offense date of February 3rd of 2022. You heard me advise you of your rights to remain silent and to have an attorney present. Do you object to a video or to your attorney assisting you by video?
No, Your Honor.
Thank you, Mr. Howard.
This is second arrest. Last was April 2021 in Tennessee. Domestic assault. It was dismissed.
Okay, thank you. Ms. Guidry?
Yes, Your Honor, we're ordering a we're recommending a $2,500 surety bond, a stay away from 876 Fox Street, Atlanta. No further contact with Claude Brown, 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, in this case, Claude Brown stated that the defendant punched him in the face several times to try to get a cell phone. The parties are in a relationship and they do live together. This incident did occur yesterday. We do understand that this is his first arrest in Georgia. However, he's a flight risk given that he does have criminal history out of Tennessee. So that's why we're asking for the recommendation.
I'm sorry, what was the amount of the bond again that the state is requesting?
2,500 surety.
And no further contact?
Yes, and a stay away. And we haven't had contact with the victim, so we're concerned for his safety.
Thank you. Ms. McLeod, is this your case?
Yes, Your Honor. My client is 27 years old. He has high school education. He tells me that he's currently employed, at least he hopes that he will still be employed at Walmart Distribution Center out in Union City. He and the alleged victim were in a relationship. He believes that relationship to be now over based on the incident that happened yesterday. He said that they had had an argument and Mr. Brown, the alleged victim, left. Then he came back and they were sitting in his car having a discussion when the alleged victim attacked him. And they got into mutual combat situation. He was hit by the alleged victim several times, and in self-defense, he also hit the victim. But he's quite content with a stay away order, Your Honor, because he doesn't want the relationship to continue because of what happened yesterday, Your Honor. But I do not think there is a flight risk or that he is a risk to the alleged victim at all, because he has stated that he doesn't want to continue the relationship and he doesn't want to see him. As far as the residence is concerned, what he tells me is that they were living together in a room that they rented from the landlord, and they each paid half of the rent directly to the landlord. Because of what happened yesterday, he tells me that the landlord has said that he does not want Mr. Brown back there, but he himself can continue to live there, and he would like to continue to live there since that's the only place that he has to live, Your Honor. I'm asking the court to consider giving him a signature bond, Your Honor, with conditions of no further contact with the alleged victim. That would be fine. He doesn't have a problem with that.
All right, thank you. At this time, Mr. Coulson is going to receive a $3,000 signature bond through pretrial services. Because I don't have information regarding the location of the victim, he is to stay away from that address. He can return one time with a member of law enforcement to get his possessions, and he is to have no further contact with the victim, last name Brown. He is to have no, okay, he is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further.
Nothing further, Your Honor. Thank you.
You said 3,000?
Thank you. 3,000, yes. All right, best of luck to you, Mr. Colson. Who do we have next?
Judge, he has a quick question.
It needs to be a very limited question, Mr. Colson. If anything, the best person to direct your question to is Ms. McLeod. What's your question?
Well, never mind that, because it's about me staying at the address, and what she had mentioned is the individual, the victim, is no longer allowed at the address to return.
I understand that, but all right, well, you're not gonna, I don't want you to inadvertently say something.
No, I'm
Mr.
not. I'm
Colson.
like, that's the only place I have to live.
All right, well, my ruling is gonna remain at this time, and
Okay.
it can be revisited. You can have your attorney, speak with your attorney about some options whereby this could be revisited, all right?
Only get all your shit, bro.
All right. Who do
Okay,
we
thank
have?
you, Your Honor.
All right, best of luck to you.
Come on, man.
Next, we got position of, next, we got position 11, Phillips.
It's 10 and 11, correct?
Correct, Your Honor.
I'm gonna need,
Yes, Your Honor.
is that Mr. Colson continuing to speak? Mr. Colson, I need you to be quiet so we can continue to move forward. All right, are you Brandon Phillips?
She talking.
You
to
are?
Oh, yeah, ma'am. Brandon Phillips.
Okay. Okay, just to be sure, Mr. Phillips, can the state verify this is positions 10 and 11 both belong to Mr. Phillips?
Yes,
Two
Your Honor,
different-
that is correct.
Okay, just verify. Mr. Phillips, you have two different cases. Your case is 22 CR 00506F, and the other one is 22 CR 00507F, each in which you're charged with theft by shoplifting with offense dates of January the 24th of 2022 and December the 18th of 2021. You've heard me advise you of your rights to remain silent and your right to an attorney. Do you object to a video hearing today?
No,
And do you object to your attorney assisting you by video?
no.
All right, thank you. Mr. Howard?
This the same Brandon Phillips from yesterday?
Yes,
Yes.
Your Honor.
He was here yesterday. What took place
Well,
yesterday?
he had shoplifting as well. I was just making sure.
Were bonds set yesterday on these cases?
No, Your Honor,
Not
that was
these.
a separate case.
Yeah, this-
I'll explain in my recitation.
All right. Just
Great,
go
thank
and
you,
go.
Ms.
You can go and go, Duncan, because this the same history.
Hey, before y'all start though, just know it wasn't nothing but some home appliances.
Oh, Mr. Phillips, Mr.
Mr.
Phillips, don't
Phillips,
say,
I
Mr.
strongly-
Phillips, stop talking. I need you to not say anything that the state might end up using it against you.
I see
Mr. Howard, I didn't see it yesterday. Can I have the history, please? Mr. Phillips, stop talking. I didn't sit yesterday. I believe Judge Law was here.
Yeah, no,
But
you
what
wasn't
is
here.
it?
You wasn't here.
I was not here. What's the
So
history?
yesterday it was 3 open shoplifting, so I guess now it's 4, without including this one. He's on probation for theft by receiving and shoplifting. That's 21 SC 178378. 482 appears in this history is what I counted. Probation violations. April 2021 terrorist threats, arrest. And I'm gonna defer to the state with the rest.
Okay, thank you. Ms. Duncan?
Your Honor, would you like me to address position 10 first?
Yeah.
Okay, this incident occurred on January 24th, 2022 at 2750 Donald Lee Hollowell Parkway. That is a Dollar General. In this case, it currently has a bond set at that $1,000 surety. In this case, officers responded to a shoplifting call at the Dollar General. When they arrived, the witness, Ms. Kachina Durham, told officers that earlier in that day, around 8:36 p.m., the defendant had taken 2 boxes of Tide laundry detergent valued at $25 and walked past the point of sale and exited the store. this witness said that this defendant habitually comes into the store and steals from the store. And this witness also said that there is video footage of this incident on camera. And position 11, the incident occurred on December 18th, 2021 at 2784 Donnelly Hollowell Parkway, and that is the Texaco. In this case, officers responded to a theft by shoplifting call, a theft call, and when they entered the store, they were told that this defendant took 2 cases of Red Bull from the freezer, walked toward the door and attempted to take it without purchasing. The clerk attempted to intercede and told him to pay for the items. And this defendant began arguing with the clerk at the time and threatening him. The clerk locked the door and the defendant forced the door open and left the store without paying for the items. As pretrial was stating, this defendant was before the court yesterday on another theft by shoplifting that took place on January 25th, 2022, and received a $2,500 surety bond. This defendant actually, Your Honor, has the three shopliftings that are were one before the court yesterday and 2 today, has been convicted for theft by shoplifting twice. One which was a felony, and that's 21 SC 178735, where he received a $3,000 surety bond and was sentenced on December 10th. And the other one is he received a $3,500 surety bond, and that's 21 CR 00205B, and was sentenced on May 6th, 2021 to 12 months probation. In addition to those 2 convictions, there appear to be an additional 2 theft by shoplifting charges open from May 9th, 2020 and April 30th, 2020. That's 2010-27 and 200972. And for these reasons, the state is requesting a total for these 2, with my apologies. And this defendant has 36 total cycles. And the state is requesting a total bond of, for both the cases, of $6,000. That's $3,000 per case. Stay away from both incident locations at that time, Your Honor.
Now, my question though, Ms. Duncan, you said that he currently has $1,000 bond set on case number 10, on position 10. Is that correct?
Yes, that was set by the judge, but that wasn't, he hasn't appeared for that one.
He has not appeared.
No, the only one that was appeared for was the one that was heard yesterday, and he
Okay.
received $2,500 from Judge Law.
Okay, thank you. All right, Ms. Kim.
Yes, Your Honor. Mr. Phillips is 26 years old. He was born and raised here. He lived here his entire life, and he has been supporting his grandmother, who is 86 years old. And he also has an uncle who is paralyzed. He has no other family members who can come and pay for his bond. He got the GED in prison, and he also has course that he's taking to get commercial driver's license. It's going to be ending at February 26, 2022, and he really needs that license to be employed. So since he has not been employed, he does not have any money to pay for. We actually ask for a signature bond. However, if it is not grantable, we would like to ask for $1,000 signature bond, surety bond, Your Honor. Remain it at the same.
Thank you, Ms. Kim.
Thank you.
At this time, he is going to receive a $2,000 surety bond for position 10. He must stay away from the incident location. For position 11, he's going to receive a $2,000 surety bond. He must also stay away from that incident location. I believe that addresses all conditions. Is there anything further from either party?
Did you say two, Your Honor, for both of them? I couldn't hear you.
Yes, for a total of $4,000 surety, $2,000 on each position.
Thank you, Your Honor.
Thank you, Your Honor.
All right, at this time, best of luck to you, Mr. Phillips. Who do we have next?
We got Ms. Martinez and up here in medical, Your Honor. I don't know.
Okay, and she's positioned, are you Sarah Martinez?
¿Usted es Sara Martínez?
Sí.
Yes.
Oh, okay, I'm sorry. Before we begin, Mr. Marcelo, will you raise your right hand, please? Do you swear and affirm that you will perform an accurate translation from Spanish to English to Spanish to the best of your knowledge and ability?
I do.
Thank you. All right. Good afternoon, Ms. Martinez.
Buenas tardes, señora Martínez.
Your case is 22 CR 000-427E.
El número de su caso es 22 CR 000-427E.
You've been charged with one count of criminal trespass with an offense date of January the 29th of 2022.
Usted está siendo acusada por allanamiento de morada y tiene la fecha que nosotros vemos aquí es el 29 de enero, perdón, del 2022.
You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you.
Usted tiene el derecho a permanecer en silencio. Cualquier cosa que usted diga puede ser utilizado en su contra.
You also have a right to an attorney at this proceeding, and your attorney is Daryl Coleman.
Usted tiene también el derecho a tener un abogado para este procedimiento. En este caso, su abogado es el señor Daryl Coleman.
Do you object to us holding this hearing by video today?
¿Usted tiene alguna objeción en que nosotros tengamos esta audiencia por video?
No.
No.
Do you object to Mr. Coleman assisting you by video?
¿Usted tiene alguna objeción en que su abogado, el señor Coleman, le esté ayudando por medio de video?
No.
No.
Thank you.
Gracias.
Mr. Howard?
She got 5 total. Marcella, you want me to give you all 4 at once?
Sure.
All right, so all the history come out of North Carolina. Last arrest was December 2020. Second degree trespass dismissed. November 2020, breaking or entering dismissed. October 2020, possession of meth, possession of drug paraphernalia, dismissed. And 2017, breaking and entering, larceny, those were dismissed. And Judge, she is homeless.
Okay.
That's all. That's it.
What?
Thank you.
I'm sorry. What was the date for the charge for meth?
The meth, hold on.
En
October 2020.
Ok. Bien, señora, dice que este es su quinto arresto. El último arresto que usted tuvo fue en diciembre de 2020, que fue por allanamiento de morada. También tiene uno de noviembre del 2020 por entrar en un lugar que no es suyo. En octubre del 2020 también tiene una acusación por tener metanfetamina y también por parafernalia. Y estos han sido desestimados. En el 2015 también por entrar a un lugar privado y en este momento se encuentra sin hogar.
All right. Now I'm going to go to Ms. Duncan. Ms. Duncan, your position on Ms. Martinez's bond.
Yes, Your Honor, the state's position on Ms. Martinez's bond is $1,000 surety, given the concern that her entire history is out of North Carolina. However, we're also requesting no alcohol, drugs, or weapons.
Let translation catch up. Go ahead, that's good.
Bien, lo que está diciendo la fiscal es que nosotros por la historial queremos pedir que la fianza sean $1,000 en efectivo. A pesar de que este caso es a pesar de que estos casos son de Carolina del Norte. Pero nosotros vamos a pedir también de que ya no pueda consumir alcohol, que no consuma drogas ilícitas y que tampoco posea armas.
No. Yo no tengo por qué pagar dinero, porque yo no cometí ningún delito. Y si algo, ahí tiene.
I want to advise Ms. Martinez, please don't say anything about your case. I don't want it used against you.
Yo no voy a...
Yo le quiero informar a usted, señora, dice el juez, que no debe decir nada sobre su caso, porque cualquier cosa que usted diga puede ser utilizada en su contra.
Continue, Ms. Duncan.
Continúe, señora Duncan.
The state is also requesting a stay away from the Solis on Peachtree Apartments that is located at 17 Peachtree Street Northeast.
Bien, entonces también vamos a pedirle que se aleje de los departamentos Solas que está en Peachtree. La dirección es 17 Peachtree Northeast.
Given the facts of this case, the state believes that this defendant is a good candidate for diversion.
Basado en esto, nosotros pensamos que esta acusada es una buena candidata para rehabilitación rápida.
However, the defendant will need to provide contact information to her attorney.
Sin embargo, la acusada tiene que proporcionarle información de contacto a su abogado.
Even though she is considered a good candidate, the state is not making the assertion that she has been accepted.
A pesar de que nosotros pensamos que ella es una buena candidata, nosotros no sabemos si ella va a ser aceptada.
The paperwork was initially sent to Ms. Gant and Ms. Thomas. However, I will forward to Mr. Coleman.
Entonces, la documentación, cualquiera que se necesite, yo se la voy a enviar al señor Coleman.
In this case, the defendant was attempting to block off the entrance to the 3rd Street section of this apartment complex.
En este caso, la acusada estaba tratando de bloquear la entrada en la parte que queda en la calle 3 de estos departamentos.
The manager of the complex, Mr. Patrick Walker, told her to move the pole that she had placed so that residents could move freely.
Entonces, el gerente de esta propiedad, que el señor Patrick Walker, le pidió a ella que sacara sus cosas de allí para que los que viven allí puedan entrar y salir de manera abierta.
She complied with the request to remove the pole. However, when asked to leave the premises several times, she refused to do so.
Entonces, ella cumplió con lo que le dijo. Sin embargo, cuando ya le dijeron a ella que se saliera, ella puso resistencia.
After refusing to leave the property, the defendant was taken into custody.
Entonces, cuando ella se rehusó a salir de la propiedad, a ella la llevaron arrestada.
Given the facts of this case and the defendant's history, along with the state's concerns, that is the reason for our bond and conditions recommendations.
Entonces, basado en los hechos, y es el motivo por el cual nosotros hemos hecho esta recomendación de fianza.
All right, just to clarify, you were requesting $1,000 surety, Ms. Duncan?
Yes, Your Honor.
Dice que la fiscalía está pidiendo $1,000 de fianza.
As well as a stay away
Y permanezca alejada.
and possible diversion participation.
Y probablemente participación de un programa de rehabilitación.
Mr. Coleman?
Señor
Yeah, I
Coleman.
will be requesting a signature bond for Ms. Martinez.
Yo le quería pedir que la dejen salir bajo palabra a la señora Martínez.
It appears that all the charges she was arrested on in North Carolina was subsequently dismissed.
Ya que todas las acusaciones que ella tuvo en Carolina del Norte fueron desestimadas.
She has an 8th grade education.
Ella tiene una educación de 8º grado.
She's not working, therefore she has no money to post for bond.
Ella no está trabajando, así que no tiene dinero para pagar su fianza.
I will request that if she is going to be referred to diversion,
Entonces nuestro pedido es que ella se la envíe al programa de rehabilitación.
that information be forwarded to the attorney in the state courtroom she will be assigned to. That really should not come to me because I will not be seeing her after today.
Y entonces esta información tendría que ser enviada al abogado que le asignen, porque después de hoy yo no voy a ser su abogado.
I can
Mr. Coleman.
give you the email address of the public defender that will be handling that case in Judge Morrison's courtroom in the chat.
Entonces yo le voy a dar el correo electrónico de la persona que va a tener su caso, el juez que va a tener su caso.
Mr. Coleman, were you able to ascertain whether or not I know she does not currently have a place to live. Does she have a stable address for a family member or any other contact information that you were
She told
able to
me
obtain?
that she does live with family, her mother and brother. If the interpreter could ask her the address.
Bien, la juez está preguntando que si usted tiene una dirección estable o vive con un familiar. Su abogado dice que usted dijo que vivía con su mamá y su hermano. ¿Usted tiene la dirección de ellos? ¿Se la sabe?
Vivo por la corte en Monroe. Sé dónde vive. Exactamente es por una casa, me acuerdo de la 101 Branch Street o 5 puntos. Y de ahí vive cerca mi mamá.
They live close to the court in Monroe, in a house. I think it's 101 Prime Street or something like that, but I'm not very sure.
She does not have an address that she can identify.
Entonces
Okay.
no hay lamentablemente una dirección que usted puede identificar.
Okay.
Okay.
All right. Is there anything further from either party at this time?
¿Algo
Nothing
más?
further.
Nada más.
Nothing from the state.
Nada
All
por
right.
fiscalía.
All right. At this time, Ms. Martinez is going to receive a $2,000 signature bond through the jail. She is to stay away from the address at 17 Peachtree Street. She is to have no alcohol, drugs, or weapons as the condition of her bond.
Bien, entonces en este momento vamos a terminar lo siguiente. Ella tiene $2,000, pero no tiene que pagarlos. Puede salir bajo palabra por medio de la cárcel. Eso sí, tiene que mantenerse alejada de la dirección donde ocurrió el incidente, que es 17 Peachtree Street. Mientras está bajo fianza, no puede consumir alcohol, drogas, ni tampoco poseer armas de fuego.
Ok, lo único que me interesa es saber si voy a regresar a Monroe, porque no sé cómo regresar.
I just would like to know how to get back to Monroe because I'm not sure how to get back.
I can assist you with that, Ms. Martinez. I have no information about how you can get back, but I am releasing you from the Fulton County Jail.
Yo no le puedo asistir con eso, pero ellos le pueden dar más información en la corte.
Ok.
¿Ok?
All right,
Yeah.
best of luck to you, Ms. Martinez.
La mejor de la
Thank you,
suerte.
Your
Honor.
May I have excuse, Your Honor? Interpreter?
Yes, have a great afternoon. Take care.
Thank you. Bye-bye.
Okay, bye-bye. All right, that's South Annex. Is courtroom 2 finished?
Lieutenant Dooley, I just want you to know what we're gonna do about position number 14. He's the guy that's refusing to get a COVID test. He's refusing to wear a mask. And I don't want to put my staff at risk by bringing him out and down the hallway. And what are we gonna do about it?
Who represents Mr. Schoenhofer? Is that Mr. Coleman? Is that your case?
No, Your Honor. Actually, I tried to have an interview with him. However, he refused to have a public defender, and he refused to sign for a waiver either, and he will be a pro se, Your Honor.
Okay, so he's refusing to speak to you entirely, Ms. Kim? Like he won't even get on the phone with you, and he wants to represent himself?
Correct, Your Honor. He does not want
Has he-
any public defender.
And has he been, this is his first day on the calendar, or has he been reset before?
He's been reset several times, Your Honor.
He's been here since the 1st of February.
And he's refusing to do,
Today's the
And-
first day he's been actually in the housing zone. He's been in intake the entire time until this morning. Because
and
he
just refuse. The only option I can think of is to try to let him speak to Ms. Kim again to waive his appearance. That's the best option, such that I can give him, I can't give him a bond if no one can speak to him. And I'd like him to be able to get a bond so he could get out. If that's possible. I can't set a bond though, unless he comes in, and I don't want to, like you said, I don't want to put you at risk or
Right.
anyone else in the facility. The only thing I can think of is could perhaps he give Ms. Kim a call and you know, maybe Ms. Kim, you could use your persuasion to get him to waive appearance, just so
My
that I
best, Your
can set
Honor.
him a bond. You could explain to him that you would just be taking care of his very limited hearing for him,
Sure.
such that he might be able to get out of the Fulton County Jail.
Yes, Your Honor.
Is that an option?
For him to
Okay.
use the phone, that means he has to
Yeah.
be, well, oh, you know what? I can use my cell phone again. I can
Or
use
is it, yeah, a jail cell phone that you could wipe off or just slide to him? Just, or even if he wanted to appear via Zoom on a cell phone, I guess if he refuses Ms. Kim's help, you could slide him a phone and I could speak with him.
I
It's
can't,
not ideal.
I can't
but-
give him the phone. Officer Norris was down earlier today and the reception was bad. That's why we were gonna try to present the phone in his face. And the reception was just too bad.
Yes, ma'am, I understand. Okay. If he could maybe just give her a call while we're still on here, I'd like to try to get him a bond, and maybe she can convince him to waive his appearance.
Can you put your number in the chat, please?
Yes, please. Sure.
Thank you.
All right, hopefully we'll be able to take position 14. If not, South Annex, how are you? Good afternoon.
Your Honor, before we begin, if I may,
Yes.
is position 15, Brian Shelton, also reset? I know that he has been in quarantine for a few days.
Is there an announcement for position 15? Does anyone know? Courtroom 2 is temporarily gone, so I'm sure we'll find out, Ms. Duncan. Who do we have at South Annex?
Good afternoon, Judge and everybody. I have position 12, Ms. Philo, and after that, position 13, Ms. Reed. Come on up, ladies. They have not heard their rights.
Okay, thank you. Good afternoon, Ms. Philo.
Good afternoon.
Your case is 22 CR 0000508G. I'm Judge Melanie Williams. In this case, you've been charged with simple assault and committing certain prohibited acts at a bus or rail station with an offense date of January the 30th of 2022. I want to advise you, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You have a right to an attorney at this proceeding. Ms. Kim, do you represent Ms. Philo?
Yes, I do.
Okay,
Yes,
I
Your
know
Honor.
that's going to be challenging. You may be getting a phone call, but hopefully we'll be able to balance this. Do you object, Ms. Philo, to your attorney appearing from a remote location or to
No.
me conducting this hearing by video?
No, ma'am.
Thank you. Mr. Howard, can I have the history, please?
This is our first. I'll take it.
Okay, thank you. All right, whose case is this Ms. Duncan? Ms. Duncan, your position, the state's position on bond?
The state's position on bond for this case will be a $3,000 total surety, $2,000 on the assault and $1,000 on the acts prohibited. Given the nature of this offense, Your Honor, on January 30th, 2022, around the area of Benjamin E. Mays Drive and Fairburn Road Southwest, there's CCTV footage, according to the report, of bus 7016, where the defendant can be observed within a verbal altercation taking place between the defendant and the bus driver at the time, which was M. Tyndale. The defendant got up out of her seat and began walking back and forth and arguing with the bus operator. And then the bus operator stopped the bus at the location indicated and asked the defendant to exit the bus. On the footage, the defendant can be observed to be throwing a bottle over the driver's partition and hitting the wall of the bus behind the driver and bounced onto the dashboard when exiting the bus at that time. Given the nature of this offense, we request a bond as stated, in addition to the condition that this defendant have no further contact with the victim in this case, M. Tyndale, stay away from all MARTA, one-day anger awareness.
Okay.
Your Honor, Ms. Philos is actually one of the best candidates for signature bond. This is her first offense whatsoever in her entire life. She's 26 years old. She has not had any troubles in the past, and she came to Georgia 22 years ago. She's been here for a long time. She has her own apartment. She has a job. She worked as a hairstylist. Now she's working at Decatur. I actually had a chance to speak to her mother as well, and I believe her mother is here to speak of her. But she can do it later after I finish this. And she has an incident because of she denies the allegation, basically, Your Honor, and she's presumed to be innocent. I believe she should get signature bond, Your Honor.
Thank you, Ms.
Thank you.
Kemp. At this time, Ms. Fowler is going to receive a $6,000 signature bond through pretrial services. She is to have no further contact with the victim, last name Tyndale. She must stay away from all MARTA locations and facilities as a condition of this bond, and she must take a one-day anger awareness course.
Thank you, Your Honor.
Thank you,
All
Your
right.
Honor.
All right. Best of luck to you, Ms. Philo.
Thank you,
We
Your
can
Honor.
now, all right, we
Next.
now move to Ms. Reed. Ms. Reed, you've heard me advise of the constitutional right to remain silent and to an attorney. Your case is 22 CR 0000493B, in which you're charged with one count of battery with an offense date of February the 2nd. Do you object to a video hearing today or to your attorney assisting you from a remote location?
Ma'am, I
Honor.
refuse the attorney or whatever, because I really don't use attorneys or whatever, because I have
So
family.
you want to represent yourself today?
I was just saying, because I have family that's like a lawyer and everything, so I really don't use outside attorneys. But yes, ma'am, I didn't hear the comment you made when y'all said something about for me refusing the attorney or whatever. But I'm gonna let that one go. But yes, I'm just here because my grandma, they
Wait,
reported.
before you tell me anything about the fact, I don't want to hear anything about your case. Before we get into that, do you want the assistance of the public defender's
No,
office
I
today?
do not. No, I don't.
Okay, so you're refusing the assistance of the
I
public
just
defender?
don't want to run around. I'm trying to just see what's going on with my case. That's all.
What it is, Miss Reed, I do not want you to inadvert. The state is on the line today. And anything that you say in talking to me and setting this bond might be used against you in this case. It's my strong recommendation that you allow the public defender's office to assist you with this. Of course, you have the right to represent yourself. I just
And I
want to be
said
clear.
no. Yeah, I said no already.
Okay. And do
Yeah.
you object to me conducting your hearing by video today?
Ma'am, I'm just one of the ladies that's trying to go home, period. So can you just work my case like you just did theirs? I'm human just like everybody else. That's all.
All
And
right,
your name,
but
Judge.
I'm
Judge.
holding, yes, ma'am. I'm holding this hearing by video. I'm not physically there with you.
Mhm.
Do you have a problem with the video hearing today?
I don't know what's that gonna lead to.
As you see, I'm talking to you on a video, right?
Right.
And we're not sitting there with each other. You're not in my courtroom today. Do you have a problem with us doing this by Zoom? Can I set you a bond via this Zoom today with this on video?
I don't mind the video, ma'am.
Okay, that's what I wanted to be clear on. Mr. Howard, can I have her history, please?
27 total between Georgia and New Jersey. The last arrest was back in June. Check your chat.
Okay.
It was for that and public indecency. A May arrest, public indecency. March of 2021, misdemeanor possession of marijuana. January 2021, PI again. 2019, entering auto. 2018,
Anything
same
violent?
charges, a chat.
Anything, well, I'm interested in anything violent or any FTA.
No.
Hold on. She got 2013 simple battery. Hold on, there. 2004 battery conviction. And then as far as New Jersey, 2018 contempt of court for domestic violence, violation of DV order, Another 2018 simple assault. That was an arrest. That's it.
Okay, thank you. Ms. Duncan?
Yes, Your Honor. This incident did occur on February 2nd, 2022 at 365 North Avenue. The victim in this case is Constance Wright. Constance is Constance. Wright is Wright. Ms. Wright is the grandmother of the defendant in this case. Given the facts of this case, Your Honor, the state is facts and history. In this case, Your Honor, the state is requesting a $5,000 surety bond, no further contact with the victim in this case, no alcohol, drugs, and weapons, and a one-day anger awareness. Based on the facts in this case, Your Honor, the defendant was in the house of her grandmother, Miss Wright, but she does not live there. They got into a verbal altercation about the defendant's lifestyle, and Miss Wright asked Miss Reed to leave, and Miss Reed became agitated and says that she was not leaving. The argument continued, and then Miss Reed kicked her grandmother in the leg, leaving visible swelling from that injury. Our victim advocate did get a chance to make contact with Miss Wright in this case. She is 73 years old.
Ma'am, my grandma made all this shit up on me or whatever.
Miss Reed, do not say anything that the state will hear that they may end up using against you, okay? Please remain silent. Let me hear from Ms. Duncan so that I can set your bond, all right? Thank you. Ms. Duncan, please continue.
She stated that the defendant is currently no longer allowed to on the premises of the high-rise senior facility where she lives. She says that the defendant does have some mental issues. She did specify, but I won't sound for those. She said that the defendant needs help, and given the victim's age in this case, our concern for the safety and health of this victim, the defendant's history, and the facts alleged in this case, we will request the bond as stated at $5,000 surety, no further contact with the victim, no alcohol, drugs, and weapons. And if the defendant is not actually allowed to stay away, we will request to stay away from that location and or a one-day anger awareness.
I'm confused, Ms. Duncan. You said you want to stay away or a one-day anger awareness?
No, I meant to say and. My apologies. I was just saying I didn't know if she was actually formally not allowed to stay away. I mean, meant to stay away, but if she isn't, we want to stay away. And if you are not inclined for a signature, surety, then a anger awareness class.
Okay. All right, Ms. Reed, this is your last opportunity to have the assistance of the public defender's office. Are you sure that you would not like to have their assistance with this?
I'm positive, and I want to speak my case. Ma'am, I don't care if they saw a physical
Ms. Reed, before you begin to speak, let me say this to you. If I feel that you are going to address anything about what happened, I do not want you to talk about the facts of the case or what happened. That will end up being used against you. The only thing that I want to discuss with you is actually, I really don't want to hear much from you at all, Ms. Reed, because I don't want to infringe on your rights. Okay. So what we're discussing today is the bond amount of which you're going to get out of the Fulton County Jail. Please do not speak to me regarding what you believe happened that day, but I will hear.
I'm not lunatic. I'm not a lunatic, ma'am.
No, I don't believe that you are, Ms. Reed. I'm not. No one is accusing you of that.
You ain't got to say nothing else about it. I just want to know what the case was going to bring, because like I said, I didn't even get to tell you my side of really what happened. My family member is in town. That's why she let me back on the premises anyway. I'm not trying to say I wasn't supposed to be. My grandma let me come there to see my family member. My brother is in town. But then he was so upset talking about why you been using drugs and all this. It's a long story to it, but I did not put my hands on my grandma, period.
Okay, Ms. Reed, thank you. I'm going to set your bond at this time, all right? At this time, Ms. Reed is going to receive a $2,500 surety bond. She is to have
Tell
no
my
further.
grandmom to pay it, cause I disagree to all of that.
She's to have no further contact with the victim, and she must stay away
That
from
ain't
the
gonna happen.
incident location. She is to have no weapons, drugs, or alcohol as a condition
I
of this
smoke
bond.
and I got legal rights to do it.
Miss Reed, please stop talking. I'm almost begging you,
What's my
okay?
time if I can't pay a bond?
You
How
will be
long do I
if
sit
you
here?
if you can't pay your case will be reset to the SAP calendar on February the 17th, where this
I'll
could be
be waiting.
revisited
Thank
at
you.
that
Have a
time.
blessed day.
Take care, Miss Reed. Best of luck to you. Does that conclude our calendar today?
Yes, Your Honor.
Thank you. Have a good one. All right. Do we want to review the calendar?
Yeah,
this
I did
time?
need to know what happened with positions 14 and 15.
15 is in quarantine was what the message just said. Is there any announcement for 14, Miss Kim?
Your Honor, they are going to try to talk with him right now. So if you are doing the calendar, call of the calendar, maybe by the end of the call of the calendar, we'll have a.
Okay, that sounds good. Let's reconcile the calendar in the meantime, and hopefully we can get position 14 to waive appearance, or we can figure out another way to take care of that position instead of bond. Miss Champion, will you please reconcile the calendar for me?
Yes, ma'am.
Thank you.
Position number 1 is a 4,500 split bond reset to the SAP 217. Position number 2 is a $3,000 good bond reset to the SAP 217. Position number 3 is a $2,500 pretrial bond reset further notice. Position number 4 is a $3,000 pretrial bond reset further notice. Position number 5 is a total of a $2,000 sign-on bond through the jail reset further notice. Position number 6 is a $4,000 pretrial bond reset further notice. Position number 7 is a total of a $5,000 good bond reset SAP 217. Position number 8 is a total of a $2,500 good bond reset SAP 217. Position number 9 is a $2,000 sign-on bond through the jail reset further notice. Position number 10 is a $2,000 good bond reset SAP 217. Position number 11 is a $2,000 good bond reset date 217 SAP. Position number 12 is a total of a $6,000 pretrial bond reset further notice. Position number 13 is a $2,500 good bond reset SAP 217. Position number 14 we're holding for. Position number 15 is going to be reset to the C calendar on tomorrow 2/5. Position number 16 is a $3,000 good bond reset SAP 217. Position number 17 is a total of a split bond $3,000 reset SAP 217.
Is the signature part of position 17 pretrial or jail?
It's sign on bond through the jail.
Any other comments, changes, or corrections? Let's hold for 2 minutes, 2 very short minutes for to see if we can take care of position 14. Hopefully there'll be an announcement from courtroom
Yes,
2.
Your Honor, I do have an
Position 6 was a $4,000 good bond.
Oh, Miss
Pretrial
Champion, will you
bond.
tell us? I have no idea. Miss Champion, can you tell us?
Yes, it's $4,000 pretrial bond,
Signature
yes.
bond. Signature bond. Okay. Hey, April.
Hey, Daryl.
Miss Kim, did you have an announcement? Did you speak to position 14?
Yes, I did. Waiver.
Okay. Will you
Yes.
please submit his waiver of appearance?
Yes.
The court concludes. Thank you. All
Thank
right.
you.
Mr. Howard, can I please have his history?
This is 9th arrest. Last was back in September for obstruction. 2 counts and trespass. That was out of Forsyth County. That's open. He has a open criminal damage to property, stalking, criminal trespass out of Fulton County.
Okay. Thank you.
Hold on, I got more.
Oh, it's more? Okay.
Yeah. He got another arrest in September, FTA for trespass. July 2021 trespass, May 2021 obstruction trespass. Another May arrest for trespass by itself. That stalking charge also come from another mayor arrest. And before that was 04 suspended license dismissed. That's
Okay.
it.
Thank you. Ms. Duncan?
Yes, Your Honor, this incident took place on February 1st, 2022 at the office of Attorney Stephen Murrin at 1875 Old Alabama Road, Roswell. Mr. Murrin, that's Murrin, is the former attorney of the defendant. And in this incident, officers were called to the office location, and because the victim wanted the defendant to leave his office, and the defendant refused to leave, saying that he would not leave until Mr. Murrin gave him, or he put a check in his hand. However, Mr. Murrin has indicated after our contact that that day the defendant came in and fired him. Either way, Mr. Murrin stated that he told the defendant that he would give the money back, but he would give it back to the mother, who is the person that paid him. He said that this altercation continued for over 30 minutes before the police arrived. And when the police did arrive, they continuously tried to tell him to leave, but he refused to, saying that he needed to have a check in his hand before he left. Officers attempted to place the defendant in handcuffs for this, and the defendant began to back away and pull his hands away from officers. After several attempts to get the defendant to calm down and to comply with arrest commands, officers were not able to get him to comply. And he pulled away again from officers. At that time, he was taken down and detained by officers on the ground. And at that time, he was still refusing to be placed in handcuffs and continued to struggle with officers. At that time, he was tased, and the victim in this case did make a statement in regards to the events that took place. He stated that he does have video camera of everything that took place in relation to this event, and that he said that this event went on for much longer than he anticipated, much longer than the officers are aware. But he would, given the nature of this offense, the state is requesting a $6,000 surety bond. That's $3,000 on each count. A stay away from the incident location, no further contact with the victim in this case, no alcohol, drugs, or weapons.
Okay, thank you, Ms. Kim. You're muted, Ms. Kim.
Yes, I was able to speak to Mr. Christopher, and he really, really wants a signature bond. So I would like to ask for that on behalf of Mr. Christopher. He has been unemployed for a long time, so he really has no other way to pay for this. And he does not have any family members to help him out to get out of the bail or bond. So please consider signature bond, Your Honor. That's it.
All right. I'm sorry, Miss Duncan, you asked for a stay away. What was that stay away address?
The stay away address is the office location of Stephen Murrin, and that is 1805 Old Alabama Road.
Okay, thank you.
I mean 1875, my apologies.
That's fine. At this time, on count one, he's going to receive a $6,000 signature bond through the jail. On count two, he's going to also receive a $6,000 signature bond through the jail. He is to have no further contact with the victim, and he is to stay away from that address that is the office of Officer Stephen Murrin. He is to have no weapons, drugs, or alcohol as a condition of his signature bond. Is there any questions or comments at this time?
No, Your Honor. Thank you very, very much.
Nothing further from the state.
Thank you.
All right. All right, I believe that concludes this. Any other questions?
Excuse me, Judge, is it through pretrial or SOB jail?
Through SOB through the jail.
Thank you. Thank you.
All right. All right, anything further? If not, we will be in recess until tomorrow, February the 5th at 2 p.m. Everyone enjoy your evening. Take care.
Have a good one. Thank you, Judge.
All right, bye-bye.
Thank you.